Court calls case People versus Jade Lathan.
Case on behalf of the people.
Overwater Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name?
The moment court begins, identity itself is challenged. The defendant refuses the name on the complaint and declares herself a principal and beneficiary. When legal identity is, the courtroom shifts fast. The question becomes, is this strategy or an issue?
She's given that. Is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade Ruth Ann Lathan and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing
I'm not
pursuant to the statute.
anything.
Here's the key moment. Defense counsel raises not guilt, not innocence. When communication breaks down and legal terminology replaces clarity, judges must protect due process. Would you push forward to trial or pause the case to evaluate mental fitness?
I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay. I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for June
6th at 9 a.m.
June 6th, 9 a.m.
6/2002.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you. Case People versus Jade Lathan.
Mr. Canapa for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who's approaching. Ms. Lathan, would you state your name for the record, please?
J. Ruth Bay, beneficiary of the principal.
Your Honor, I have spoken with Ms. Lathan several times. We reviewed some of the discovery. We are looking into some potential resolutions. I'd ask to adjourn the probable cause conference. I would ask for more than 2 weeks.
August 29th, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case of since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker, 15400, and AA Condolis, 02002, claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life, and certainly not an officer of the law. On file with public defender Kenneth Overwater right here to my left. a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. The representation on the day of the arraignment on February 2024 to help grant me my freedom on bond has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied two main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These two things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7th.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
After reviewing the record, the court denies dismissal and notes delays came from the defense, not the prosecution. A reminder that speedy trial claims must match procedural history. The case moves forward. If you value real courtroom breakdowns like this, like the video, share your thoughts below and subscribe for more.